Have you ever heard of a high-stakes international lawsuit that just vanished? We're talking about a case between two nations with accusations of war brought before the highest court on the planet. But right when things were about to get really intense, it disappeared from the record. So today, we're going to unpack just how and why a case this huge could simply go poof. So here's how we're going to break down this wild story. First, we'll look at the explosive accusation that started it all. Then we'll see the wheels of justice start to turn. After that, we hit a completely unexpected reversal. We'll see how the case was officially shut down, and we'll end on this really intriguing little detail that honestly just raises more questions.
All right, so our story kicks off at the International Court of Justice, the principal judicial body of the UN. This is where one country is making an incredibly serious complaint against its neighbor, and it's setting the stage for a massive legal showdown.
And just get a load of the language here. This is not some minor disagreement over a border. We're talking about acts of armed aggression. The Democratic Republic of the Congo, the DRC, is basically accusing Rwanda of breaking the most fundamental rule of international law, the UN Charter itself. I mean, the stakes really couldn't be any higher.
So on June 23, 1999, it's official. The DRC files its case against Rwanda at the ICJ. The battle lines are drawn, the papers are filed, and this major international legal fight is about to get underway.
Now, once a case like this gets filed, the wheels of international justice start to turn. But you gotta understand, they turn slowly. This isn't a TV courtroom drama. The court doesn't just rush into things. First, both sides have to lay out their arguments in writing.
Okay, so the first big document is called a memorial. The easiest way to think about it is like the defendant's opening statement. This was Rwanda's big chance to officially respond to all those heavy accusations and start telling its side of the story. And right after that, you have what's called the counter-memorial. This is the rebuttal. It's the plaintiff's turn, in this case the DRC, to read everything Rwanda just argued and then come back with a detailed written response trying to pick their defense apart piece by piece. And this timeline really shows you that methodical, deliberate pace. The case gets filed in June of '99. It takes almost a full year for Rwanda to submit its defense in April 2000. Then the DRC gets an extension for its big comeback, pushing their new deadline all the way to January 23, 2001. You can feel it, right? Everything is building towards this one critical date. So the stage is set. The deadline for the DRC's all-important rebuttal is just days away. After a year and a half of legal back and forth, everyone is waiting to see what they have to say. But what happens next? Well, absolutely no one saw this coming.
You're going to want to remember this date, January 15, 2001. We're just 8 days before the DRC's legal papers are due. A letter shows up at the court, and believe me, it is not the document anyone was expecting.
And there it is. The letter is from the DRC, the same country that started this whole thing, and it says they want to discontinue the proceedings. Can you believe it? After all that time, all that legal maneuvering, the plaintiff suddenly wants to just walk away from their own case.
So, what happens now? Can a country really just decide to drop its case at the highest court in the world? Well, it turns out there's a formal and actually pretty simple procedure for exactly this situation. The very first thing the court does is loop in the other side. They shot a copy of the DRC's letter right over to Rwanda and basically said, hey, you've got until January 23rd to tell us if you have a problem with this. And the process is really as simple as 1, 2, 3. First, the DRC sends in the request. Second, Rwanda has to agree to it. And the very next day, on January 22nd, Rwanda sent its own letter saying, yep, we're fine with this. That cleared the runway for the final step, the court's official order. And just like that, it was all over. On January 30th, 2001, the president of the International Court of Justice signed off on the order. The case was officially, formally removed from the court's list. The whole lawsuit just vanished.
But hold on, because this story has one last little twist. It's a fascinating detail, and it's hidden right in the wording of the DRC's letter, the one asking to drop the case. It's just a single phrase, but it kind of changes how you look at this whole thing.
Now, look closely at the legal language they used here. The DRC didn't just say, we're done. They added this very specific condition. They reserved the right to come back later, but on new grounds of jurisdiction. This was not a simple withdrawal. This was something else. So what does that actually mean in plain English? It means this wasn't really a final surrender. It was more like a strategic retreat. The DRC was basically putting the court and Rwanda on notice, saying, okay, we're ending this particular legal fight right now, but don't get too comfortable. We might be back.
And that, right there, leaves us with the central mystery of this whole affair. Why would the country make an accusation as serious as armed aggression, take it to the world's highest court, only to back out at the most critical moment, while at the same time leaving the door cracked open to sue again? The official court record, well, it doesn't say. It just tells us what happened, leaving the why as the great unanswered question.